SJC-13086, Commonwealth v. Zahkuan, J. Bailey Sweeting.
Hear from Attorney Fraunhofer.
Thank you, Your Honors. Elaine Fraunhofer for Mr. Zahkuan Bailey Sweeting. I know these facts are fairly simple in this case, but I'd like to just hone in right away on a fact that came to my mind when reading the Commonwealth's brief. As you know, Alyssa Jackson pulled into the parking lot of a KFC restaurant.
Could you talk a little louder? Sorry.
Sorry.
Yeah.
A few seconds later, 3 New Bedford gang unit detectives pulled into the parking lot behind her with their blue lights on because she made an unsafe lane change. Detective Takuna stepped out either first or simultaneously with Mr. Raquan Paris, and Mr. Paris stepped out and asked why he was being stopped. A reasonable question, especially given the passengers likely would not have known Ms. Jackson had cut someone off, but particularly reasonable for Mr. Paris to ask, given that all 3 officers testified they had stopped this young man numerous times, either for traffic stops or in the street inquiries or both. And here's the really significant detail. When Paris asked this question, why are you stopping me now? The officers don't tell him why. Instead, Takuna just keeps ordering him, get back in the car. According to every single officer, Paris just kept asking them, why? Why are you stopping me now? And instead of answering him, telling him this is just a traffic stop, Takuna escorts Mr. Paris to the back of the car. How infuriating this must have been for Mr. Paris. They handcuffed this man who was constantly being harassed by the police and still just would not have the decency to just tell him this is just a traffic stop. But in its brief, the Commonwealth argues that Mr. Paris was, quote, derailing what he had been told was a traffic stop. But in fact, the record shows he wasn't told that. And that's kind of an important detail in the context of why Mr. Paris was getting angry.
Does the judge make a finding on that issue? I can't remember. Does the judge make a finding one way or the other on whether Mr. Paris was informed?
He doesn't make a finding, but the officer's testimony is clear that he just keeps asking them, which would indicate he hasn't been told. And so it's significant how dismissive these gang unit detectives were to Mr. Paris's perfectly reasonable request. And in the context of what we know about how often, they clearly know him very well, he knows them very well. And so it undermines the government's claim that the police could infer that his, quote, uncooperative behavior meant Mr. Bailey Sweeting might be armed and dangerous. The officers were correct to admit that their assumptions about what Mr. Paris's behavior could mean was really nothing but a hunch. But equally important, Paris's behavior is literally the only observation of any physical or verbal behavior by anyone that the government can point to as grounds for inferring Mr. Bailey Sweeting, a passenger sitting quietly in a car stopped for a minor traffic infraction, is armed and dangerous.
Let's go through all the objective facts too, okay? Just so we have the totality here. So we have 3 young men in the car. What are their criminal backgrounds?
We don't know anything about Mr. Cortez as far as we know. He doesn't have a criminal background. Mr. Bailey Sweeting, 3 years prior, had a firearms offense, and Mr. Paris, who stepped out.
He was convicted? I can't remember. It's a juvenile?
He was committed to DYS,
Okay,
yeah.
juvenile offense, yeah.
And Mr. Paris, a year and a half prior, had a firearms offense. That was the extent of what we know.
Okay, so in the third person, there's a video of him with
Oh, yeah, he's
something
a rap musician, and the police had been told that a month before, they had been told he had a video up on YouTube in which he was displaying what they suspected could be an authentic firearm, but we don't know that that's a...
And the police are familiar with all 3 of the gentlemen, is that right?
I mean, in the sense that they were told about, they say, at least somebody there was told about the video. They know all of them know Mr. Paris. Not all of them knew Mr. Bailey Sweeting. I think 2 of them said, we just know he's been categorized as a gang member. Right. And so with respect to the totality of these circumstances, the other factor that, the appeals court relied on was that...
The gang evidence, just go through the objective, I think you're dividing that between sort of objective and hunches and stuff. I'm just trying to understand, what do we know objectively about their membership in gangs?
Well, that's an important question, because what we know objectively is that the officer said, we know he's a gang member. We know Paris is a Bloods gang member. And they said about, one of them said, we know Mr. Cortez is some gang member from Fall River or something, not a named gang. And we know Mr. Bailey Sweeting is a gang member. The only one that we have anything more than just we know is Mr. Bailey Sweeting. And defense counsel elicited through Dacuna's testimony about how he became, quote, validated. And so objectively, we know that he was, quote, validated a gang member by just hitting this 10-point scale that the police create, the New Bedford police created. And the way he got validated, what's significant.
From what I understand, there were three components to that. There's some hand signaling I didn't quite understand. What is the?
Well, the hand signal is an either or. He had a photo taken with a fellow gang member. He had a photo taken with a group of gang members, and he was photographed wearing a red bandana. That would get him 10 points. He also allegedly was photographed or seen, quote, throwing known
I
hand
thought
signals.
he attested to being a gang member. Is that not correct?
Not until after the stop. So at the point of the stop, what the police knew objectively at the time of the stop.
Before they pat frisk him or after they pat frisk him?
They alleged that he admitted being a Bloods gang member when he was being booked.
Being booked, not before the pat frisk.
Not before the pat frisk, definitely not. So I just want to say, taking all that as a given, that let's assume that the evidence that they are gang members was actually reliable evidence that you could count on to say, yes, they are gang members, for whatever that means. Just having Mr. Paris, who has been harassed by the police, step out and ask, why are you stopping me now? The police refusing to answer his question, and that he gets angry, clearly is not
Can I
specific.
ask one last factual question? So the stop follows Ms. Jackson cutting off somebody.
Yes.
Is there testimony about, is there honking, or is there sort of, you say Mr. Paris doesn't understand why they're being stopped. I'm trying to understand what we know about the cutting off in traffic. Did the police observe it? Describe what the testimony is about that.
Well, I guess I'll just say for the position I would think is important is that it's clear that there was no evidence that they're trying to evade the police. He was an unmarked car.
No, you say that Mr. Paris doesn't know why they're being stopped, and I'm just trying to understand.
I'm not saying he doesn't know why, but I will say that could really well be the reason, because if you're a passenger in a car and the driver, makes the right to change lanes because they're trying to get to the restaurant, you might not know that somebody is,
Right,
in your
no,
blind
but
side.
I'm just trying to get a sense of how dramatic the incident was. They're immediately pulled over after this
Unsafe lane change.
unsafe lane change. I'm just trying to understand, was there, what is, you're telling me Mr. Paris doesn't know. This is news to me, so I'm like dwelling on what actually happened, and so what he would be informed of by the actual traffic incident.
Well, all I'm saying is that an unsafe lane change by a driver is not something a front seat passenger would necessarily see, because it's something that the people behind you
No, but I
would
know, but if someone's honking at you and screaming at you and giving you, a nasty
Right.
symbol, you know what happened. I'm just trying
But there
to-
was none of that, none of
Okay.
that. Sorry. I'm sorry, I could have cut to that right away.
Mm-hmm.
So I guess what my point is that the appeals court and the Commonwealth try to fill in the evidence. So I'll just say clearly that Mr. Paris's behavior, uncooperative behavior, could not possibly get you all the way from he's behaving uncooperatively, I think he's distracting us, I think Mr. Bailey Sweeting has a gun on him and he's ready to use it. But what the appeals court does is it fills in that enormous gap in the evidence by saying, well, these guys were gang members and two of them had firearms offenses. But that evidence merely explains why these gang unit officers might have been predisposed to speculate that there was a gun in the car or to have a hunch. But that's not specific articulable facts.
Right, but they do have, it's the criminal records is, to me, a very important fact, because it's not a hunch. You're not saying this person looks scary to me. you know that they've got gun offenses. So, I mean, that's an important fact, right? It may not be enough, but that's not just a hunch about guns. That's a past with guns.
Well, I think the courts, our decisions say that, you know, a 3-year-old offense is a pretty old offense to be saying, well, you had an offense 3 years ago. So even if you know, grant you that you have this sort of heightened concern, you still don't have anything that ties this, you know, anything that's happening, any furtive movements, any suspicious behavior, any exchanging of glances that says, Mr. Bailey Sweeting, who's sitting compliantly, quietly in a car, this was not a stop because, you know, there were shots fired, gang dispute, drug deal. This is just an unsafe lane change. So even people who have a criminal record sometimes have an unsafe lane change, and you have to have some evidence that gets you there. And I think what's really striking about this case is that the Commonwealth, or I'm sorry, the appeals court and Commonwealth, nobody has been able to find a case that comes remotely close to holding that the evidence presented here supports that suspicion. The cases they cite, Commonwealth versus Da Silva, Commonwealth versus Elise, really underscore how much of an outlier this case is. These gang unit, again, as I said, these gang unit detectives, they were not in Ms. Jackson's car because they were responding to a gang dispute, as in Commonwealth versus Elise, or a reported possession of a gun and narcotics, as in Da Silva. And in both Elise and Da Silva, when the police arrive at the car, or and Da Silva at the apartment, the police are observing specific details which corroborate their concern, you know, movements, verbal responses, and so on.
I haven't done the research you've done, but we're really not going to find cases where people are pulling someone over with with gun offenses, and that hasn't provided the necessary support for a pat frisk. I understand the law is evolving, but are you really saying when we go back and dig up sort of the bulk of these cases, we're not going to find any support for pat frisks in those contexts?
Yeah, I think the reason you're not going to, Your Honor, well, first of all, I haven't, the Commonwealth hasn't, the appeals court hasn't, the suppression hearing judge hasn't. And the reason you can't find these cases is because what's different here is there was nothing, Mr. Bailey Sweeting was just sitting in a car, compliantly, quietly, even, you know, and surely you would need something that would suggest that he's about to use a weapon, that he might have a weapon on him, that they have some connection to Mr. Paris. And that kind of, so I just want to say that this case marks a significant erosion of the protections citizens have had heretofore in dealing with the police. But the second important flaw, the appeals court's decision is erroneous because even if we assume that the officer's testimony asserting that the passengers were gang members reliably established that meant they were dangerous and likely to be armed and violent, that's not what the government's evidence, not at all, what the government's evidence actually established in this case. And that's important because the appeals court wrote that it rested its conclusion that the pat frisk was constitutional on the fact that the police labeled Mr. Paris and Mr. Bailey Sweeting Blood's gang members. And really what the appeals court was saying there is they rested its decision on everything they decided or imagined that that label meant. Guns, violence, loyalty to fellow members. That's what really they're saying. But we know from Detective Zakuan's testimony that the New Bedford police don't have to have seen a citizen commit a crime, an act of violence, and even a nefarious act affiliated with that gang to categorize that person, label them a gang member. And we know that actually, they validated Mr. Bailey Sweeting as a gang member of the Bloods gang, never having seen him commit a crime affiliated with that gang, do anything nefarious, anything violent. And we have no idea why they labeled Mr. Paris a gang member. And the government's failed, excuse me. Here the government failed to present proof that the label reliably established, you know, threats, violence. They just didn't present enough evidence. The appeals court inappropriately filled in what it imagined that label meant without actual proof. And that is before you even consider the studies and the data that show the entire, you know, this police categorization, gang categorization process is not tested, incentivized to be overbroad, and incredibly racially biased. You'll see all the statistics in the amicus brief and in my brief on that but I believe it's a black resident of New Bedford is 27 times more likely to be categorized as a gang member than a white, a white resident. And that's the same everywhere you look at the studies, Boston, Chicago, New York. So the data really underscores how unreliable gang categorization process is, and yet despite the unreliability, the appeals court decision, rather than putting curbs on how this gang categorization label is used, actually expands it. And so that it really opens the gate to greatly expand its use. And given what we know about who the police affix that label to, it further erodes the Fourth Amendment Article 14 protections for the very people who are already over-policed and who are already the victims of systemic racism. I do want to address one other point that the Commonwealth raises in their brief, and that is that the officers were distracted, and therefore, and you had, allegedly gang members in the car with firearm offenses, and so they were entitled to be suspicious. But there's 3 problems with that. Zahkuan testified that, definitely at the suppression hearing, the judge was trying to, the ADA was trying to build that case that they were distracted. But Zahkuan testified that he was actually trying to keep his eye on the people in the back. And then on cross-examination, he was asked, was Mr. Bailey Sweeting doing anything? Was Mr. Cortez doing anything suspicious? And he said they were not. He confirmed that Mr. Bailey Sweeting was just sitting there quietly. But even if Mr. Paris's protest had, however briefly, distracted the officer's attention, really all we have then is the absence of any evidence that Mr. Bailey Sweeting was sitting quietly. We don't have any evidence that he was making any furtive movements. And most importantly—
We're making a furtive movement. Would that be enough, given that he had a gun offense, a 3-year-old? If he had a 3-year-old, I'm sorry.
I couldn't hear the beginning.
If he had I'm just saying, if he had a furtive movement, if there was any, would that have changed this? Would a 3-year-old gun conviction and a furtive movement be enough? And recent validation, I know you question the validity of the validation, but
yeah,
would that be enough? Or what is enough?
Well, I guess, Your Honor,
because I'm trying to figure out where the line
definitely be a
is.
closer case, because at least then you'd have some specific articulable fact that's particularized to Mr. Bailey Sweeting. So that would move you—
So again, if Mr. Bailey Sweeney does no movement whatsoever, there's no grounds, and it's not a rhetorical question, it's a question, there's no grounds to pat frisk him, even if others in the car are engaging in furtive movements or other things? I'm just trying to get a sense of your rules here, because
Sure,
we normally do this totality of circumstances, and it's it takes into account all the different factors, but I'm trying to get a sense. You say there's not enough, but I'm trying to figure out what would add to it and make it enough.
Yes, I would say that certainly you would certainly need something that, as the court in Elise said, it was there was movement in the car exactly where the person who they asked to get out of the car, and that was an exit order case, not a pat frisk case, was located. And so, again, this isn't the case here, but I would say if the driver was making furtive movements, then it would make sense to maybe, given that. But actually, I'm going to step back and say, no. Here's the problem with this case, really, in my opinion. The whole idea that the police could say, Mr. Paris is upset, he's behaving uncooperatively, he used to behave cooperatively, when everything you're hearing shows exactly why he's being upset. It's just really a stretch to say, oh, we think that must be criminal behavior, we're going to get everybody out of the car and pat frisk them. And I just want to point out that the suppression hearing judge heard all this testimony, and he did not find that the police were actually distracted. What he said was that he found the police believed Paris was trying to distract them. And I just want to point out, Your Honors, that I'm not arguing that police have no knowledge of gangs, that gang evidence never has to, never has any relevance. But I think the 2 things that you really have to have, and that I think would be important to put forward, is that it has to be reliable, has to be shown to be reliable, and it has to be relevant to the case that you're dealing with. And so in this case, all we know nothing about their officers' training about gang units. All we know is that their duty was to work with the gangs and know the gangs, whatever that means. We know that you don't have to have committed any crime, any act of violence to be validated a gang member. We have no idea why they validated Mr.
What
Harris.
is, in your view, what is reliable gang validation? What's required to
Well-
reliably because we obviously don't want gangs. They're causing mayhem out there. So if someone is in a gang and it's a bad gang, we obviously want to know that, right? So what is a proper validation of gangs?
I would think that if you're going to have somebody testify, especially because it's such a loaded, as you could see from the appeals court's
I
decision.
understand mischaracterizing someone as being in a gang is a terrible thing. What I'm trying to figure out is when it's accurate, it's also concerning. A police officer dealing with an actual gang member who's armed is a scary thing. So what do we do? How do we decide whether something is a properly validated gang in your view?
I'd say that, I want to just note that in the amicus brief, they make a point of saying it is analogous to how this court has dealt with the label high crime area.
I'm just trying to, because there's always there are two issues, but I mean, how do you deal with, help us evaluate what is good validation?
Okay, so I will say that, just using other validations, having the officers explain how they would have, what their training is, that they would be able to know that somebody is a gang member. Saying my duties are that doesn't tell you anything about what they know. Having the test be something that is a validated test. I think it is in the amicus brief that they point out that it is like this self-created, completely untested, not validated anywhere. So that's, like with Mr. Bailey Sweeting, he would not have been, based on those criteria, a gang member under the Boston police criteria. So that just tells you right there, like, this is completely arbitrary. It's really completely in the discretion of the police. So something that has some soundness, something that's been tested that establishes that this actually predicts that somebody is in a gang, that would be the second thing.
A good example of that would be?
Okay, I will say,
It's always easy to sort of, what is the great line? I have you write a book so I can criticize it, but I'm just trying to help us write the book.
well, really, you're really, in this kind of situation, what you're really using these police officers for when they say, oh, he's a gang member, you're really using them as an expert. And so in all of your expert cases, you want something that indicates, like, I have, so yeah, you raise a good point,
I'm just looking
No,
for,
but
you don't want us to do it poorly, and you've put a lot of thought into it. It would be helpful if you gave us some, useful way of validating these, as opposed to saying, all this is poorly done. But again,
it's not-
you're over, and I've asked you plenty of questions, so I will
And
relate.
I understand the reason for raising it, but she may not be the person who can answer that question, and we may just have to see if somebody comes up with something. Can I ask a different question, though?
Yes.
You mentioned that here we know why Paris was upset. He felt like it was unjust. He's always being stopped, and, there was no reason here that he may have known in his head. So does that mean because because here there is a reason, what if next case there is no reason, except somebody may be trying to distract the police from the person who actually has the firearm? Is the rule to be, as long as the defendant has acted with, has not made any actions or moves to seem suspicious, then they shouldn't be pulled out and pat frisked?
I would say yes, Your Honor. I mean, otherwise you're in a situation where literally being compliant subjects you to being pat frisked. I mean, it's kind of an absurd rule to have it otherwise. And so it is possible that in a situation, somebody, the hunch is correct, but, the Fourth Amendment sometimes has to let people who have contraband go. Otherwise, you are opening the floodgates to innocent people being, hundreds of innocent people, as happens.
Isn't that the federal rule?
isn't, I'm sorry. Yeah, I'd
Does
have
it
to-
under the federal jurisprudence that the law enforcement can do just that?
That they can order somebody out of the car is under the federal jurisdiction. Yeah, but for no reason, right? Just they
Right.
stopped you, they can order you out. But not pat frisk. And this was, the issue here was that Mr. Bailey Sweeting was pat frisk, and there needs to be individualized, specific articulable facts that raise a concern about that person, given how intrusive that act is.
Okay.
Okay, thank you so much.
Thank you, Your Honors.
Okay, Attorney Stern.
Good morning, Your Honors. Shoshana Stern for the Commonwealth. Just to respond to a couple of factual points that my sister made. On page 15 of the Commonwealth's brief, Detective Kubik is talking about Paris getting out of the car, questioning the reason for the stop, and says, one of the detectives informed him that it was a traffic stop and to sit back in the vehicle, he didn't want to get back in. That's the first transcript, pages 13 through 14. So it is in the record that he was told the reason for the stop early on. I don't know, the judge said he was told that repeatedly. I don't know if it's in the record that he was told repeatedly that it was a traffic stop as opposed to repeatedly to get back in, but that happened before all of before he was brought to the back of the car, before anything else. And just with regard to the gang evidence, in this case, the basis for gang identifications that came in was the bases that were asked about, that essentially one defense counsel said, they were asked, what Detective DeCunha was asked, what does it mean to be validated? No one was asked, what is every reason that you happen to think that the defendant is a member of the Bloods? They discussed the checklist, but defense counsel, no one asked, why do you think Mr. Paris is a member of the Bloods?
Could you talk a little louder?
Yeah, we need
Sorry,
to, yeah.
I'm not
Can you
good with
bring
the math.
the microphone a little closer to you, just,
Sure.
yeah, I think. You don't have to,
Yeah, I don't
I
know
don't want
if
to
you-
make you bend over, I just wanted
Yeah.
to see if we
No,
could get
I
that.
always have, because I'm short, this is always a little bit of an issue. Did you hear what I said before, or do you need me
Yeah,
to?
no, I think we heard it.
Heard.
But, yes, so, to the extent that defense counsel interrogated the reasons for particular classifications, they are discussed in the record. But no one asked, again, why do you think Mr. Paris is a member of the Bloods? Why do you think Mr. Paris is a member of the United Front Gang? And there's some evidence in the record. To the extent with Mr. Cortez, it may have been, we don't know if there was anything else besides Boston told us that might be the entirety of it. But again, these officers all know all of these people. Sometimes they know different things about the people, and we're going with collective knowledge. But to the extent that there were a rule, I think that the Commonwealth has an affirmative burden to put in the record why we think that this person is a current gang member. I don't know. I can't speak to that at all, but that would bring in potentially a lot. Maybe they would say, yeah, actually, we found his name on a list, we don't know. But if it's, here's our entire history with this person, here's everything we know, I don't know that bringing that in as part of the Commonwealth's case, so to speak, would necessarily be of the benefit to the average defendant without the discretion of their attorney about whether they want to investigate that.
But let's say none of that, we're not talking about any of that. Let's just say that we're just talking about what was observed at that time.
Yeah, sure.
And what was observed at that time was whatever else anybody else might have been upset about for the basis of the stop or that they were told, that Mr. Bailey Sweeting was doing none of that. And so back to Chief Justice Budd's point, I think we're all concerned with where's the line and where is it localized to Mr. Bailey Sweeting and what he was doing or not doing in terms of the justification for the Pat Frisk.
And I do think that is the central issue in this case. And it is an unusual fact pattern. I did not find law in either direction, but I'm not necessarily surprised that there haven't been many cases in which you even had a plausible fact pattern where you have the actions of another person that might tell you something legitimate and particularized about somebody who isn't seen to do anything. That's not likely, I think, to happen all that often, but it happened here, so here we are. And I think that it is, again, I think it's clear you can't just say, one person's suspicious, so we search everybody in the car. That is a stout, that does come up a lot. But in terms of the particular situation, if one accepts that the police had a basis to be concerned that Paris was trying to distract from something going on in the car. And again, I think there was evidence that most of the time, D'Acunha said he was trying to look into the car from the back, but I mean, that, at least at one point. But there's no evidence that they were all able to keep watch on the car all of that time. So in a situation, which again, I don't know that would arise that often, but, you know, the motion judge and the appeals court, et cetera, found happened here, if there is reason to think that the one person who is acting is doing so for a reason in collaboration with someone in the car, and there's reason to think that there's a firearm in play, that would be a rare circumstance in which you wouldn't necessarily have to see the people in the car doing anything. If you see the people in the car and they're not doing anything, then that also is a different circumstance, because that would, I think, would negate.
I think the defendant's saying, though, that there's too much of a analytical gap to get from Mr. Paris's behavior to, oh, this is a ploy, as opposed to, oh, Mr. Paris's behavior, he's really upset. And how do you figure out which one it is? But
Well,
sorry. Go ahead, I'm sorry.
I mean, I think you can get beyond, he's just upset insofar as, I mean, you know, there's various discussion, you know, could he legitimately have been upset? Leaving aside the fact that he was told it was a traffic stop, I think that the reasons for worrying that he's distracting them, as are on the record, are not based on what he's saying. I mean, not just what he's saying. I mean, again, he's protesting, he's continuing to protest, he's escalating the protest after he's been told what the reason for the stop is. He appears to be about to punch a cop that he's known for a while. And I mean, maybe it's not, but they had reason to think, and they all knew him, and they knew that this was not how he acted under any circumstances.
On the debate about whether or not he was legitimately ticked off about being overpoliced versus whether he was trying to distract the police, the motion judge made a specific finding that he was trying to distract the police, correct?
I believe so,
And this
yes.
was litigated below.
Yeah, I mean, I think that, and I don't think you can, I mean, leaving aside the question of whether he was over-policed, which isn't really explored in the record, there isn't a basis one way or another. I think that you couldn't find error based on the idea that,
But either way, these are issues that were in front of the motion judge.
yeah. And I mean, defense counsel didn't litigate them in the way that is now argued below, possibly for reasons. I mean, suggesting that, I mean, one of the arguments was, you know, Paris has nothing to do with
But I think it turns on what Justice George's indicated. So if we accept what the motion, well, we have to, unless it's clearly erroneous. The motion judge finds that Paris is acting, is trying to distract the police. We know that a pat frisk is intransitive between people. And that's the federal rule, right? That's not. So we have to have a reason to believe that this defendant is armed and dangerous.
Yes.
That's really where the rubber meets the road. And it turns on whether or not you buy the inference that he's armed and dangerous because his buddy is trying to distract the police, and he's got prior gun cases.
I mean, I think that once you get beyond the disputes and the facts, based on what the motion judge found, the inference is what it is, and you buy it or you don't. I mean, I know that that's, you know, I sort of go into detail in my brief, but, you know, it's either you think it's a good inference or you don't think it's a good inference. But that, I mean, again, as I argued, if he is trying to distract from something in the car, it doesn't make sense for him to be distracting from something that is just sitting there hidden, because that doesn't, I mean.
But how do you make that leap, though? He could be trying to distract from something in the trunk. He could be trying to distract from something in the glove box. He could be trying to distract from, you know, who knows? But that's the point.
Well, I mean, there's a whole range of possibilities.
Right, well, that's the
of-
thing, right?
Yes.
Yeah.
I do argue that I think it is more likely, if you're assuming that he has a plan that makes some sort of sense, that if he jumps out of the car and starts trying to distract from something in the trunk, he is drawing attention to the car and everything in it. But that's the argument.
I'm sorry, that he is drawing attention to the car?
Well, I mean, if it's a routine traffic stop, then if someone gets out and becomes increasingly aggressive with the police, it is not going to get less attention for the car than if,
So it backfired, basically.
sorry?
It backfired what he was trying to
I
do
mean,
was not a
yeah,
good
I mean,
idea at all.
You know, I think that one could conclude that a slightly better plan might be something that the police should assume maybe he has, but
But that's the whole, I mean, we're talking about assumptions.
I mean, it is a question of what's a reasonable inference, and I think that it's, you know, what makes this case, I mean, in the appeals court disagreed amongst themselves about several different things, but it's sort of, you know, I would argue, it's the sort of inference that I guess, I mean, they're not, I mean, it's not clear to me from the case law whether a hunch is, by definition, anything that's not reasonable suspicion, or whether there's space between a hunch and reasonable suspicion. But I mean, they have a chain of logic here. They're not just going completely by the seat of their pants.
But no,
Whether
no,
it's
but
quite good enough
if
is
you
the
think
question.
about what, I guess both Justice George and Justice Gaziano were saying, even if Paris is acting unusual for what he, you know, from the way he usually acts, how do you get to the defendant?
I mean, so our argument essentially is that if you buy the inference that he is trying to distract from something in the car, then the people in the car, in light of, I mean, again, the question is what? Then you look at who's in the car. They know about the firearms histories and the gang memberships,
And they're sitting quietly.
as far, to the extent that they've been observed, which is not complete.
But what they've seen is they're sitting quietly. So how could the defendant have, there's nothing the defendant could have done at that point to avoid the pat frisk?
That sometimes, I mean, I think that there are situations in the law where, for various reasons that aren't the fault of a person, you can end up getting frisked that
Well,
are not.
that's for sure.
But I mean, not even, leaving aside like, you know, you happen to match a very detailed description of someone who just did something, like very detailed. It'd be that, so I mean, there are situations where you cannot craft a rule so that it never results in a pat frisk of somebody who's minding their own business. You can try to keep it as narrow as possible so that it only happens when lightning strikes you out of the sky, and that was just like an unfortunate confluence of circumstances. One other example, if you're visiting somebody who has an all-persons-present warrant out for the drug operation you don't know about, I mean, there's been police review of the warrant, but you're just associating with the person. But again, so you're not, you know a lot of facts, you just don't know the relevant facts there. So it is, I think it is not inherently always going, I don't think it's necessary. I mean, as I argue in my brief, it's not necessarily, you can't necessarily craft a rule that doesn't take into account that there's no way that other things going on around you, no matter what they are, can get you in trouble.
No, that's
not with
true.
Counsel,
No,
is the fact that Mr. Bailey Sweeting had a prior gun offense, is that determinative of whether or not it was reasonable to pat frisk? And I asked that, let me ask it in another way. Let's just say that there was no prior record, zero. And so all you have was a finding by the motion judge that the other gentleman was trying to distract them from something. So what's the plus factor that gets added to Mr. Bailey Sweeting? Is it just that he had a prior gun offense?
I think that is probably the single most, I mean, overwhelmingly the single most important factor.
So let me follow up with that. Someone else had asked you, well, is there ever going to be a time where that's not going to be a factor? Let's say it was 10 years ago that there was that this prior gun offense happened. What is it just in and of itself about that gives you the plus factor to say, okay, now's good? Because if you say that, if it's 10 years ago, 15 years ago, 20 years ago, who cares?
I think it would attenuate into the distance. I don't know at what point. I think that an armed robbery adjudication from 3 years ago has not done that yet. So I think that is crucial. I mean, and there is law that for example, it has to be a firearms offense. Your other criminal record, even if it's violent, is not relevant here at all.
I forget on the facts, but wasn't it that they had other instances of this group of young men who had more recent activity with firearms?
Paris had, the two of them had arrested him with a firearm in a car.
When was that?
That was in June 2016. It was about 18 months earlier. He was out on bail. He hadn't been tried yet for that offense.
Okay, so the other guys had more recent firearms, and when was the video?
Carlos Cortez, New Bedford had found out about it from Boston. I think it was testified within a month. And the judge was very interested in sort of how do you know it's a real gun, and asked one of the officers.
That
to
was within a
describe-
month of the stop?
Yeah. So one of the officers actually put that as the initial reason why they decided that they needed to search the passengers, was that Carlos Cortez was in the car. You know, as you get a reducing percentage of the car being people with recent firearms offenses, I'm not sure exactly what happens, but I think that the overall dynamic here was very likely important, that you have 3 out of the 4 people in the car with all these things they know about them, but with all of them within the last 3 years having gun offenses of various degrees of, I mean, the defendant's the one with the adjudication, and again, armed robbery with a firearm, not just caught with one on him.
I'm just trying to understand, so, I didn't mean to cut you off.
I'm done.
So because the gun offense, so if the defendant here didn't have a gun offense, and I may be repeating Justice George's question, but if he didn't have a gun offense, they still can pat frisk him here?
I mean, there might be other circumstances that could
Well, I'm just,
fill in for that, but I think on these facts, probably not.
so again, and Mr. Sweeney, the other guy who has the video, no gun offenses, but a video.
There's a video with
Did
him.
was that improper to pat frisk him? Because he has no offenses.
I mean, I think that there was the video within the month, and there was they said he was waving what looked like a real firearm, and the judge sort of interrogated that. Said it looked like a Glock. They could see the slide, I think.
And I'm also trying to get a sense of, if there wasn't any gang evidence here, or it was invalid, the validity issue I'm still confused about, but if we had just a prior offense, a 5-year-old gun offense, but no current gang activity, can you pat frisk that person?
I mean, I think that the gang evidence is a plus factor among all of the other evidence once you're doing that analysis.
So are all of these necessary then? Not only do you have a gang, in order to justify this pat frisk, particularly of the person who wasn't doing anything, we need all of this combination that they had a gun offense, they're a current member of a gang. Is that your view? Or I'm just trying to get a sense. Your opposing counsel, I can't tell exactly what would be enough, but I can't tell sort of the same question from you. Are all of these critical here? Because we don't obviously want someone with a 5-year-old gun offense to always be pat frisked at every stop, right?
Yes.
The Commonwealth doesn't think that's appropriate, right?
No, Your Honor. I mean,
I take it, given the problems with validating gang evidence, we don't want anyone who has any of these gang affiliations to be pat frisked every time there's a stop, right?
yes, and I think all 3 officers agreed that, 3 gang members in a car, some of whom they've arrested recently for gun offenses, would not warrant anything except the traffic stop but for Paris's conduct. So it would have to be a situation.
So it's that hunch gets us, because it is a hunch. I mean, the judge says they believe this, but they describe what they're saying as a hunch, right?
Well, one of the officers, after being encouraged repeatedly by defense counsel, agreed to a question where she characterized it as a hunch. I don't know that, like, the first time she said, well, it was a hunch, right? And he said it was more of a fear. And then there's one other time where he agrees it's a hunch. I mean, he can't stipulate that they had a hunch, but I don't even know what quality of evidence that is that he thought he had a hunch. I mean, this court can determine it was a hunch, but that's a different question. I think the officers thought that they were acting on reasonable suspicion, certainly, which isn't the standard either. I think the problem with totality of the circumstances, the good thing is it can get at very specific circumstances, but the hard thing is it's not easy to say, here's the math of exactly which total circumstances you would need. In this case, I think probably you need all of them, but I don't know in terms of making a rule for, I mean, another case might have other important differences that would factor in. I mean, I think you can write legal guidance that doesn't, I mean, the nature of this is it's hard to have a bright line rule. You can write a decision that will provide clarity on what isn't it, on the test to be applied, but it's always the nature of balancing factors tests is that they're always going to be specific to each particular case. And
So in that factor analysis, how should we look at the validation of gang membership? Got any guidance for us on that? Was it good enough here, or was it sort of undisputed here? How do we deal with that? If you have any help on that.
well, I think here, I mean, again, it was mentioned and it was interrogated somewhat by the defense what the basis was, but it does not appear, I think from the record, that their basis for thinking that these people were gang members was specifically because they'd done this checklist as opposed to the totality of what they knew about them, that they also ran through a checklist and used it as shorthand. Certainly if you had a case where the only reason someone was considered to be a gang member was that they had this validation from.
But we have cases out there where somebody gets, put in a gang database because they're friends with the wrong person and they got the picture taken, right?
I mean, I think I think it's an issue that would be a great subject for an evidentiary hearing in a case where it was raised. I mean, I think that it's a question worth pursuing whether, there is currently a lot of discussion going on with the legislature and, Boston city government and other things about ways to deal with this, whether the exclusionary rule, given that, as you note, some people are definitely really gang members and that has significance. The question of whether an evidentiary rule in this case, such as Amici proposed, would be useful for either officers to apply on the fly or as a way to get at the problem of sloppy gang lists, I think is questionable.
Well, the issue of concern is that if just by way of analogy, just saying high crime area just fits too many cases into a situation where there's nothing specific about the location or specific about the circumstances. And so we have a concern that you can't put too much into that factor, or there's going to be all sorts of implications that are not good. And so I think the defendant's saying with the validation that you just can't throw around the term and necessarily figure out how much it adds to the totality of the circumstances. And I think that's Justice Kafka's point, which seems important.
I think that, as I said, I think it's a conversation worth having. I don't think that this case sort of presents a basis where it was, I think there were probably reasons that wasn't dug into deeper at the hearing. Again, these people mostly know each other, but in the general issue, I think it is different from the high crime area in the sense that you can be potentially mistakenly on a gang list, but it's not that, with a high crime, it's an issue because they can both be used as proxies, but it's not, all sorts of people, as is stated in the case law, live in high crime areas minding their own business. Some people might be accidentally on a gang list, but presumably the ones who are correctly identified are not. I guess we could get into an argument about whether gang membership is relevant to anything, but I think that there is a case that correctly identified gang membership is, whereas if you correctly identify somebody as living in a high crime area, you don't know anything about them. They could be anybody doing anything, they just happen to live there. Whereas if you're correctly on a gang list, again, you can get into the question, there's, I think as Justice Kafka was getting at, there's what is the way to be given legitimate gang evidence, whatever that is, and are gang lists a way of actually ascertaining who's actually a gang member? And I think those are separate questions that have to be dealt with on separate bases, essentially, that you can't, yeah.
Okay.
Thank
Thank
Your Honor.
you. Appreciate it.
Thank you, Your Honors.